Welcome to G Fun Facts Online, where we unpack the science and tech that's shaping our world. Today, we're diving into something that's gone from science fiction to our daily reality: artificial intelligence. It's in our phones, it helps doctors, and it's even starting to drive our cars. But as AI gets smarter and more independent, it's crashing headfirst into a world of laws written for humans, not for machines. This has sparked two massive legal battles that could define the next century. First, who pays the price when an AI makes a mistake? And second, who owns the art, music, and writing that AI creates? Grab your headphones, because we're about to navigate the uncharted legal waters of AI liability and copyright. Let's start with the question that keeps lawyers and tech CEOs up at night. Who pays when AI fails? Imagine this: a self-driving car gets into an accident. A medical AI in a hospital misreads a scan and gives a wrong diagnosis. A hiring algorithm used by a major company is found to be discriminating against certain groups of people. In each case, someone has been harmed. But who do you sue? The person who was in the car? The doctor who used the AI? The company that used the algorithm? It's not so simple. The problem is what experts call the AI supply chain. An AI system isn't usually built by one person or one company. Think of it like a complex machine with parts from all over the world. You have the developers who build the core AI model, like the massive language models that power tools like ChatGPT. Then you have the data providers who supply the mountains of information used to train the AI. After that, you have companies that take that general AI and fine-tune it for a specific job, like medical diagnostics or legal research. And finally, you have the end users, the companies or individuals who actually deploy the AI in the real world. So if that medical AI makes a mistake, where did the fault happen? Was it a flaw in the original design? Was the training data biased or incomplete? Did the hospital customize it improperly? Or did the doctor misuse the tool? It's a tangled web of responsibility. And to make things even more complicated, we have the infamous black box problem. With some of the most advanced AI, even their creators can't fully explain the internal logic behind a specific decision. The AI works, but they don't know exactly how. How can you assign blame when nobody can pinpoint the exact moment things went wrong? Since we don't have a lot of specific AI laws on the books yet, courts are trying to adapt old legal ideas to this new reality. The two main ones are negligence and product liability. A negligence claim is basically about failing to be careful enough. To win a negligence case, you have to prove that the defendant owed you a duty of care, that they breached that duty, and that their failure caused your injury. For an AI developer, this could mean they didn't take reasonable steps to ensure their system was safe. But what is reasonable care for a technology that's evolving every single day? It's a moving target. Then there's product liability. This legal concept holds manufacturers responsible for injuries caused by defective products. If we decide an AI system is a product, then its creators could be held liable for design defects, manufacturing flaws, or for not warning users about potential risks. A key part of this is consumer expectations. If an AI doesn't perform as a reasonable user would expect it to, it could be legally considered defective. For extremely risky AI applications, some experts are even talking about strict liability. This means that if the AI causes harm, its creator or operator is responsible, period. It doesn't matter how careful they were. The idea is to force companies developing potentially dangerous tech to exercise the absolute maximum level of caution. Realizing that these old laws are like trying to fit a square peg in a round hole, governments around the world are racing to create new rules. The European Union has been a trailblazer here. In the summer of 2024, its landmark AI Act came into force. This is the world's first comprehensive legal framework for AI. It uses a risk-based approach, putting the strictest rules on high-risk AI systems, things used in critical infrastructure, medical devices, and hiring. The EU also tried to pass an AI liability directive, which would have made it easier for victims to sue by introducing things like a presumption of causality, basically shifting the burden of proof. That proposal was withdrawn, but the EU is still updating its product liability directive to explicitly cover software and AI, opening another door for people harmed by faulty AI. The United States is also in the game, with a patchwork of court cases and proposed laws at the state and federal levels. California, for example, is looking at creating its own comprehensive AI regulations. The challenge for everyone is finding the right balance. We need to create clear paths for victims to get justice, but we can't create so many rules that we stifle the innovation that could bring huge benefits to society. Now, let's shift gears from when AI breaks things to when it makes things. The rise of generative AI tools that can create stunning images, write poetry, compose music, and even write computer code has thrown copyright law into chaos. This brings us to another pair of multi-billion-dollar questions. Can a work created by an AI be copyrighted? And is it legal to use copyrighted books, articles, and art to train these AI models in the first place? For centuries, copyright law has been built on one bedrock principle: human authorship. To get a copyright, a work needs to be the product of human creativity and originality. This is where AI runs into a brick wall. The U.S. Copyright Office has been very clear on this. It has repeatedly stated that a work generated entirely by an AI, without any creative input from a human, cannot be copyrighted. Federal courts have backed this up, but what if a human is involved? The Copyright Office has issued guidance to clarify the gray areas. They say that if a human uses AI as a tool, much like an artist uses Photoshop, the final work might be copyrightable. The key is how much creative control and contribution the human had. If you use AI to touch up a photo or to brainstorm ideas that you then write yourself, the human-authored parts can still be protected. However, and this is a big one, simply writing a text prompt for an AI to generate an image is not enough to make you the copyright owner. The office's view is that in that scenario, the AI is making the expressive choices, not you. They also now require that if you apply for a copyright on a work that contains AI-generated material, you have to disclose that fact and specifically exclude the AI-created parts from your claim. So you could copyright a graphic novel where you wrote the story and the dialogue, but the AI-generated images themselves would not be protected. They would fall into the public domain. This isn't a settled issue globally, though. In Canada, the Intellectual Property Office actually allowed a copyright registration that listed an AI system as a co-author with a human. And in a groundbreaking 2023 case, a court in China granted copyright protection to an AI-generated image, arguing that it reflected the intellectual effort of the human who prompted it. The global debate is far from over, but perhaps the most explosive issue at the intersection of AI and copyright is about training data. To become so powerful, these AI models are trained on absolutely massive datasets, often scraped from the internet. This includes billions of images, articles, books, and songs, most of which are protected by copyright. AI developers argue that this is a fair use of the material. Fair use is a legal doctrine in the US that allows for the limited use of copyrighted work without permission for purposes like criticism, news reporting, research, and education. The key argument from the AI companies is that their use is transformative. They aren't just copying and reselling the original works. They're using them to learn statistical patterns to create something entirely new and different. They compare it to the Google Books case, where a court ruled that Google scanning millions of copyrighted books to create a searchable database was a transformative fair use. But creators, authors, and artists are firing back, and they are not happy. They argue that this isn't fair use. It's massive, industrial-scale copyright infringement. They claim that AI companies are building multi-billion-dollar commercial products on the back of their stolen labor. They also argue that this directly harms the market for their work, as the AI can now generate content that directly competes with them. This has led to a wave of high-profile lawsuits. Groups of authors, major news organizations, and visual artists have all sued the big AI companies, and these cases are working their way through the courts right now. So what's the verdict? The U.S. Copyright Office has said there's no simple yes or no answer. Whether training an AI on copyrighted material is fair use will likely be decided on a case-by-case basis. Meanwhile, the EU's AI Act has tried to create a middle ground. It includes rules that require providers of AI models to provide summaries of the copyrighted content used for training, and it respects a system where copyright holders can opt out of having their work used for commercial training purposes. So where does this leave us? We are standing at a new legal frontier. The laws for liability and copyright that we are building today will shape our digital world for generations. They will determine how we innovate, how we protect citizens from harm, and how we value human creativity in an age of intelligent machines. The path forward won't be simple. It will require adapting old laws, writing new ones, and working together across the globe. The goal is to strike that delicate balance, a balance that protects us from AI's risks, fairly rewards creators for their work, and still allows this incredible technology to develop for the benefit of all. The debates and legal battles are just getting started, and we'll be watching closely. Thanks for tuning in to G Fun Facts Online. Join us next time as we explore another fascinating corner of our ever-changing world.